In 2008, the United States Supreme Court made a decision that reshaped constitutional law in a way few people fully grasped at the time. For the first time in American history, the court held that the Second Amendment protects an individual's right to possess a firearm for lawful purposes like self-defense inside the home. That case, District of Columbia versus Heller, didn't just settle a legal debate. It opened the door to a much bigger question that courts are still struggling with today. How far does that right actually go? And now, more than a decade later, that question is back in front of the Supreme Court in a very specific and controversial form: assault weapon bans. So here's the question I want you to think about as we begin. If the Constitution protects an individual right to keep and bear arms, does that protection extend to modern, semi-automatic rifles often labeled as assault weapons? Or can the government restrict them in the interest of public safety? Let me know your thoughts in the comments. To understand why this issue is so legally complex, and why many analysts believe assault weapon bans could be in trouble, we need to step back and look at how the Supreme Court has interpreted the Second Amendment over time. The Second Amendment itself is only 27 words long. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. For most of American history, courts didn't clearly define whether this protected an individual right or a collective right tied to militia service. That changed in 2008 with Heller. The court, in a 5-4 decision, ruled that the Second Amendment protects an individual's right to possess a firearm unconnected with militia service, particularly for self-defense in the home. But, and this is critical, the court also made clear that the right is not unlimited. Justice Scalia, writing for the majority, explicitly noted that long-standing prohibitions on things like possession by felons or restrictions on dangerous and unusual weapons could still be constitutional. 2 years later, in McDonald versus City of Chicago, the court extended that right to apply to the states through the 14th Amendment. This meant state and local governments were now equally bound by the Second Amendment. At that point, you might think the legal framework was settled, but it wasn't. Because while Heller established that individuals have a right to possess firearms, it didn't clearly define how courts should evaluate gun regulations. That gap led to years of conflicting decisions in lower courts. Most federal appellate courts developed a two-step framework. First, they would ask whether a law burdened conduct protected by the Second Amendment. If it did, they would then apply some level of scrutiny, often intermediate scrutiny, to decide whether the law was justified. Under that approach, many courts upheld assault weapon bans. They reasoned that even if these weapons were protected to some degree, governments had a strong interest in reducing gun violence, and the restrictions were sufficiently tailored to meet that goal. But in 2022, the Supreme Court fundamentally changed that approach in New York State Rifle and Pistol Association versus Bruen. Bruen rejected the two-step framework entirely. Instead, the court introduced a new test rooted in history and tradition. According to the majority, when evaluating a gun law, courts must ask whether the regulation is consistent with the nation's historical tradition of firearm regulation. If it is not, then the law is likely unconstitutional. This shift is at the heart of why assault weapon bans are now being challenged across the country. Under the Bruen framework, courts are no longer supposed to weigh policy arguments like public safety against individual rights in the same way. Instead, they must look backward, often to the 18th and 19th centuries, and ask whether similar restrictions existed when the Second Amendment was adopted. This creates a difficult question. Were there historical analogs to modern bans on semi-automatic rifles? Supporters of assault weapon bans argue that there were historical regulations on particularly dangerous weapons. For example, certain types of weapons like Bowie knives or trap guns were restricted in some jurisdictions. They argue that these laws show a tradition of regulating weapons perceived as especially dangerous. Opponents, however, argue that these historical laws are not close enough to justify modern bans. They emphasize that semi-automatic firearms are widely owned today by millions of Americans for lawful purposes, including self-defense and sport. Under Heller, weapons that are in common use for lawful purposes are generally protected. This brings us to one of the central legal questions. Are so-called assault weapons in common use? Many lower courts are now grappling with that issue, and they've reached different conclusions. Some courts have upheld bans, reasoning that even if these weapons are popular, they can still be regulated because of their perceived dangerousness. Others have struck down similar laws, finding that widespread ownership places them squarely within the Second Amendment's protection. And that disagreement is exactly what often prompts the Supreme Court to step in. Now, it's important to pause here and clear up a common misconception. Many people believe that if the Supreme Court rules against assault weapon bans, it would eliminate all gun regulations. That is not accurate. Even the most expansive interpretations of the Second Amendment recognize that certain regulations are permissible, such as restrictions on possession by felons or laws regulating sensitive places like schools and government buildings. Another misconception is that the term assault weapon has a fixed legal meaning. In reality, it's a statutory definition that varies by jurisdiction. Most laws define it based on specific features, like detachable magazines or certain cosmetic characteristics, rather than how the firearm functions mechanically. That ambiguity is part of what makes these laws legally contentious. Let's bring this down to a practical level. Imagine a law-abiding citizen who owns a semi-automatic rifle for home defense or recreational shooting. In one state, that firearm might be perfectly legal. In another, it could be banned outright based on its features. The question before the courts is whether that kind of variation is consistent with a constitutional right. What do you think? Should constitutional rights vary that much from state to state when it comes to firearms? Share your perspective below. Now, from a legal analysis standpoint, the Supreme Court faces a delicate balance. On one hand, its recent decisions, especially Bruen, suggest a strong commitment to protecting individual gun rights based on historical tradition. On the other hand, the court has repeatedly acknowledged that the Second Amendment allows for some regulation. So where does that leave assault weapon bans? In my analysis, the outcome may hinge on how the court defines two key concepts: common use and historical analogs. If the court concludes that semi-automatic rifles are in common use for lawful purposes, and there is substantial evidence that millions are owned nationwide, then bans on those weapons could face serious constitutional challenges. But if the court accepts broader historical comparisons, such as regulations on dangerous weapons in earlier periods, it might uphold certain types of restrictions. Legal scholars are deeply divided on this issue. Some argue that Bruen's history-based test makes it very difficult to justify modern firearm regulations that didn't have clear historical counterparts. Others believe the court will allow for more flexible analogies, recognizing that technology has evolved in ways the founders could not have anticipated. There's also an important institutional consideration. The Supreme Court is often cautious about making sweeping rulings that could have far-reaching consequences. Striking down all assault weapon bans nationwide would be a major legal shift with significant practical implications. At the same time, leaving the current patchwork of laws unresolved could perpetuate confusion and inconsistency across the country. Another key point is what the court's decision would not do. Even if assault weapon bans were struck down, that would not automatically invalidate all forms of gun regulation. Background checks, licensing requirements, and restrictions on certain categories of individuals would likely remain intact as long as they align with historical traditions recognized by the court. And again, it's worth emphasizing that this discussion is for educational purposes only. If you have questions about how firearm laws apply to you personally, it's always best to consult a qualified attorney in your jurisdiction. As we look ahead, several cases working their way through the federal courts could provide the Supreme Court with an opportunity to clarify this issue. When the court decides to take such a case, if it does, it will likely shape Second Amendment law for decades. So where does that leave us right now? Assault weapon bans are not automatically unconstitutional, but they are under significant legal pressure in the wake of Bruen. Lower courts are divided, legal standards are evolving, and the Supreme Court has signaled a willingness to revisit how these laws are evaluated. For everyday Americans, this isn't just an abstract legal debate. It affects what firearms people can legally own, how states regulate them, and how constitutional rights are interpreted in modern society. Before we wrap up, here's one more thing to consider. How should courts balance a constitutional right written in the 18th century with technologies and societal concerns that didn't exist at the time? There's no easy answer, and reasonable people, including judges, disagree. To close, here are the 3 key takeaways. First, the Supreme Court's recent decisions, especially Bruen, have fundamentally changed how courts evaluate gun laws by focusing on history and tradition rather than modern policy balancing. Second, assault weapon bans are being challenged because it's unclear whether they align with that historical tradition, particularly given arguments that these firearms are in common use for lawful purposes. And third, whatever the Supreme Court ultimately decides, the ruling will shape not just gun policy, but how constitutional rights are interpreted in a rapidly changing world. Understanding this issue matters because it sits at the intersection of individual rights, public safety, and the role of the judiciary. And those are questions that affect everyone, whether directly or indirectly. If you found this breakdown helpful and want more clear, fact-based legal analysis, feel free to share your thoughts and keep asking questions.